What do you do in focus groups that most lawyers skip?
Well, for one thing, the statistically significant number of people. If you were going to do a focus group in a conference room, call in 160 or 175 people, you're going to have a much huger expense than if you do it by the internet. The second thing is we make sure that we have unbiased jurors by the way that they're selected between conservative, middle of the road, and liberals. You don't want to stack it with your types of personalities or leanings. So that's different. And then the last thing is we look very carefully at what are the drivers of the decision making. What really is the point where the jurors say, I can't get over the fact that this happened or that happened. And that makes for a compelling reason why I'm voting the way I am.
So, what part does juror selection play in your overall process?
Huge. That's where you make the connection with credibility. And the way we do it, we don't try to deselect people. We want fair, even-handed people. And the best way to do that is tell them that. If you read our voir dires, we literally explain to the jury, we want an even playing field. If you're leaning towards the defense, then you need to tell us that. If you're leaning towards the plaintiff, you need to tell us that. Because otherwise, the parties have spent hundreds of hours preparing a case, thousands of dollars of preparation, and the game's not going to be fair because there's basically a ringer in there that regardless of your position, they're just against your case. Maybe they don't believe in personal injury lawsuits. Maybe they don't believe in discrimination cases. Who knows? Got to ask.
Um, so if so, we've already got your website, we've got your contact information. What final thing do you want to leave with our audience if they're a law firm out there and they have a case, they're kind of unsure about what to do? What would you tell them?
I would tell them that if they feel like they need assistance in understanding how to get the truth to the jury, to overcome any defenses that have been put up against them, that they're worried about the defense. They've probably been told time and again, you can't win this case, your plaintiff is at fault. We have methods to show that the plaintiff is not at fault. And it goes to the heart of the theme of the case of where's the problem? What's the backstory? What's the metastory? Where's the greed? Where is the choice that was made that was wrong that led to this disaster? It didn't start with the plaintiff on X date. It was there for a long time.